This week, the Supreme Court came out with an important judgment that could significantly affect UAPA cases. A two-judge bench of Justices C.T. Ravikumar and Sanjay Karol ruled that the 14-day time limit prescribed for granting sanction for prosecution under the Unlawful Activities Prevention Act 1967 and the UAPA Rules 2008 is mandatory and not just directory in nature. Now, before we begin, let's look at the basic laws involved in this case. Rule 3 of the UAPA rules lays down timelines for a central government authority to make recommendations to the center within 7 days of the investigating officer gathering evidence. On the other hand, Rule 4 allows the center to decide on the sanction for prosecution within 7 days of receiving the government-appointed authority's recommendations. Both these rules closely relate to and derive their validity from Section 45 of the UAPA, a provision which essentially disallows courts from taking cognizance of offences under the UAPA without the previous sanction of the central government, the state government, or any other officer authorized by it. Essentially, the UAPA rules provide a 7-day period within which the concerned authorities to make its recommendations based on materials gathered by the IO or the investigating officer, and a further 7 days period for the government to grant sanction for prosecution after having considered the authority's report. Thus, this total period comes to 14 days and was also being referred to when the court emphasized the mandatory nature of the time limit for granting prosecution. Now, let's take a look at the facts of this case. The judgment was passed in the case of one Phuleshwar Gope, who was alleged to be an associate of the People's Liberation Front of India, a militant Maoist outfit formed in 2007 in Jharkhand. Charged with the various provisions such as those relating to offences like criminal conspiracy, raising funds for terrorist acts, holding proceeds of terrorism, threatening witnesses, and becoming a part of unlawful associations or assisting their operations in any way, Gope had first moved the Jharkhand High Court seeking to quash the letter and order approving the sanction for his arrest. Before the High Court, Gope argued that the sanction order should be quashed on account of violating the 14-day timeline, as the same was issued 2 years and 6 months after the letter dated 12 May 2017. He also said that the requirement of an independent review under Section 45 while giving sanction was not complied with, and the sanction order was passed mechanically or without application of mind, given that both the recommending authority and the center had granted sanction within a day each. Now, Section 45 requires independent scrutiny and application of mind at each of the 3 stages, that is, by the requisitioning authority, by an independent agency, and then by the sanctioning authority. However, the High Court refused to quash the sanction order or letter, thereby paving the way for Gope to approach the top court. What did the top court rule? Referring to the timelines prescribed under the UAPA rules, the court said that when such timelines are provided along with the usage of the word shall, particularly in the context of laws like the UAPA, they cannot be considered a mere technicality or formality. Adding that such timelines demonstrate a clear intention on the legislature's part, the court said that while the UAPA is aimed at curbing unlawful activities and practices detrimental to the national security, and it provides authorities with ample power to undertake and complete all procedures permissible under the law, at the same time, interests of accused persons must also be safeguarded and protected. The court also said that the executive is expected to work with speed and dispatch in furtherance of protecting national security. In doing so, the court also put a stop to conflicting interpretations delivered by the High Courts of Maharashtra and Jharkhand on the subject in cases like Vinod Kumar versus Union of India and Mahesh Kariman Tirki versus State of Maharashtra, which said that the timeline for sanction of prosecution is not mandatory but only directory in nature. Finally, the court said that the procedures concerning sanctions in such legislations like the TADA and the UAPA are meant to be followed strictly to the letter and more so to the spirit, while adding that even the slightest variation from the written word would cast a shadow of doubt on the resultant proceedings. Stay tuned to The Print for more legal explainers on the top news of the day. This is Khadija Khan from New Delhi.